This content is about the sources of law. In this content you will watch an animated video wherein an experienced prosecutor will be discussing different sources of law with a group of prosecution officers. You will see presentation slides. During this session, the participants will ask different questions and the facilitator will explain the same.
Hello friends, how are you doing? I am a prosecutor for the last 24 years. Have served in different districts. Today we are going to discuss different sources of law. Do you have any idea about the same?
Yes, sir. I have read a book wherein Salmond, an English jurist, has classified the source of law into formal sources, legal sources, material sources, and historical sources.
Perfect. Now, I would like to draw your attention towards the presentation wherein the formal sources are explained. Formal sources. These are the sources from which law derives its force and validity. Formal sources of law has laid down three valid sources from where the law derived is entrusted upon, and which encompasses validity. 1. Will of the state. The will of the state is mostly drawn towards public's welfare, though might not good for a class of people, but for majority. How you are enjoying the same?
It's amazing.
Now I will like to draw your attention towards second part of the slide, which speaks of the will of the people and judicial precedents.
Can I?
Of course.
2. Will of the people. Laws are meant to fulfill the requisite demand of the people of the nation. Whenever new problems fall before people, which need urgent solution, then the state after valid ratification can approve such demand into law. Will of the people as a source of law is mainly dominant in a democratic nation, where the voice of people is the prime consideration, and of optimum concern of the law-making authority.
Precedent.
Are welcome.
3. Judicial decisions or precedents. Judiciary lays down the reason behind its judgment and it answers all the concerns which arise, making the law more authentic. Judiciary also play a very important role in assisting the state to formulate laws, and such laws turn out to be more definite and reliable.
Now referring to the material sources. These sources are divided into legal material sources and historical material sources. Can anyone elaborate the legal material sources?
Interested?
Yes, please.
There are 3 legal material sources: customary law, precedents, and legislation.
If you can explain that. We have little idea of the same.
It is a habitual conduct, observed uniformly and voluntarily by the society. Here I would like to add that these are 2 types of customs. Custom having sanction. These are obligatory and are forced by the state, whereas customs without sanctions are non-obligatory and are observed due to public pressure. Now, I would like to invite your attention towards the essentials of valid customs which are being explained here. 1. Antiquity. A custom to be recognized as law must be proved to be in existence from time immemorial. 2. Reasonableness. A custom must be reasonable in order to become a law. 3. Continuance. It must be practiced continuously without any changes, from time immemorial. 4. Certainty. A custom to be a valid one must be certain. 5. Consistency. Any custom must not come into conflict with the other established customs. There must be consistency among the customs. 6. Conformity. It must be in conformity with statute law. I hope you are enjoying the sessions.
Yes. This is really amazing.
Okay. Now we are moving towards precedent as source of law.
Can I explain the same?
Yes. You can explain.
Gray defined precedents as a precedent covers everything said or done, which furnishes a rule for subsequent practice. A judicial precedent is considered to be one of the most important sources of law. I would like to explain doctrine of precedents as well. The doctrine of precedents is often considered to be a very rigid doctrine within the court hierarchy. Every court is bound to the previously made decisions by the courts higher than them. Secondly, to a certain extent, the higher courts are bound by their own decisions.
This is really encouraging that you all are having good ideas about the topic. Now we are going to discuss that the decisions by Supreme Court are binding upon all courts across the country. Can anyone explain about the decisions of the high courts?
District courts within its jurisdiction.
Wonderful. These are binding upon all subordinate courts in the province. Now we are going to deliberate upon doctrine of state decisions. 1. To stand by decisions and not to disturb settled matters. 2. Based on public policy and expediency, that is, fast decision-making if based on previous judgments. 3. It secures the certainty and predictability. 4. The rule of stare decisis is not an inflexible rule. Ration decidendi. It is the reason behind the decision. Obiter dicta. These are the remarks of a judge which are not necessary to reaching a decision, but are made as comments or illustrations. Any idea about another source of law?
Yes. Legislation.
Splendid. Anyone who can explain the same?
There are 3 types of legislation: supreme legislation, subordinate legislation, and delegated legislation.
Anyone from participants who can explain supreme and subordinate legislation?
Yes, I can. Legislation is supreme when it proceeds from the sovereign and is incapable of being annulled or controlled by any other legislative, but the sovereign is bound by the law too. It is the law which decides the identity and the composition of the sovereign. I can also explain delegated legislation, if allowed.
These.
It means legislation made by bodies other than the legislature. The term delegated legislation is commonly used in two senses. 1. It means the exercise of rule-making power by the executive, under the authority delegated to it by the legislature. 2. It means the output of the exercise of that power, in the form of rules, regulations, by-laws and orders.
The last source of law is historical. This is as informal source of law. It has not got any formal recognition by the law. These are of two kinds: equality and conventions. Equity is one of the principles on which natural laws have been based upon. It is the principle that everyone should be treated equally, whereas the other type of the historical source of law is conventions. These are contractual relations and treaties between countries which are bilateral or multilateral in nature. In short, law generally convey from the source explained above. Thank you very much for your patient hearing, and I hope you must have enjoyed the same.
Yes, it was an remarkable presentation.